Hazard in City Park does not affect city's recreational use immunity. Jeremy Pauley et al. V. City of Circleville, case number 2012-1150, 4th District Court of Appeals, Pickaway County.
Dirt mounds had been created at the park that the boys were using as sled riding hills. And this was a common practice here. All the witnesses who have testified have confirmed that sled riding tracks were observed on the mounds and so forth. He's riding the hill at one point and he's reaching down towards the bottom when he strikes a fixed object and he feels himself go numb. Jeremy's rendered a paraplegic as a result of this incident, and his friend Kevin Baisden goes back to the mound to retrieve the sleds and observes at the bottom of the mound where Jeremy had stopped, there's a railroad tie-like object covered by the snow that's approximately 5 feet long. The problem is that now this inference is being stretched to the point where the defense in this case wants it to cover debris, trash, debris, dangerous chemicals, whatever. Whatever is on that park, however it got there, their position is it's recreational property. And that just doesn't make any sense.
But the statute doesn't talk about recreational property. It talks about the character of the individual who is using the park. The statute says no owner of a premises owes any duty to a recreational user to keep the premises safe for entry or use.
Right.
So, was your client a recreational user?
He was.
Well, if the statute says that no owner owes a duty to a recreational user, isn't it up to the legislature to create an exception?
You can look through other statutes across the country, and you can see those legislatures have put in different types of limitations. And one typical one is the one that is found in New York that's cited in the brief, but it's similar to many others where it says the section does not limit liability which would otherwise exist for willful, malicious failure to guard or warn against a dangerous condition, use, structure, or activity. Now, the Ohio legislature could have put those types of limitations or other ones that would go along with the plaintiff's view of what the limitation should be, but it's really a legislative call. The legislature determines the purpose behind this act is to encourage landowners to open up their property free of charge for recreational purposes. And in providing this no-duty rule that is very broad, it achieves that purpose.
The Supreme Court of Ohio ruled on October 16, 2013, that under state law, a city is immune from liability for injuries resulting from a sledding accident on a pile of topsoil which was being stored in a city park and contained debris. The court held that the city owes no duty to recreational users to ensure that a park is safe for entry or use. The 5-2 decision, authored by Justice Sharon L. Kennedy, affirms the judgment of the 4th District Court of Appeals.